Hello everyone and welcome. Today I wanted to chime in a little bit about something that is going on that has everybody up in arms. It has to do with the judge that put the stop to President Trump's temporary travel ban. There's a question out there that I think a lot of people can't answer just because they're just a little bit ignorant of understanding exactly how our Constitution works and how our system works. And it's the question of what really is the job of a judge? What is their role in our system? Most people kind of are like, well, they're to interpret the law. But that's, again, a little bit vague, and I think people need to understand exactly what that means and some of the context behind and logic and rationale behind what it means for a judge to interpret the law. So, first of all, let's just talk about what it means to interpret something. It essentially means to find the meaning of it. Okay, well, if you were the one who did not write something down, someone else did, and you were interpreting what they had said, your job would be to, the most common sense answer would be that you would be trying to figure out what was the meaning that that person was trying to convey. I'll use a simple example. Let's say that I write on a stone, people should not smoke. Okay, I write it on a big rock. 200 years go by and some people discover this rock. And the first person comes up and they say, what this person was trying to say is he was trying to say that we should not inhale smoke from tobacco products, which was a common thing that they were doing at that time. Okay, so that's the first guy. Then another guy comes along and he says, he looks at it and he says, my interpretation of this is that what this man was trying to convey was that we should be kind to our neighbors. Now remember, the original saying said people should not smoke. So this guy just made a false interpretation. In other words, the quality of an interpretation is based on how accurately you convey the meaning of what the original person was trying to get across. I mean, that should be common sense, but in legal systems with attorneys and lawyers who are really good at what they do, simple common sense things suddenly aren't so common sense anymore. So what you should do, what a judge is meant to do, is to basically be a servant of the lawmakers. Remember, it is not the judge who creates the law. It is the lawmakers who've been given the authority to do so. Now, there are some red herrings and some counter arguments that are brought up frequently that honestly they don't hold much weight. The first one is that, well, we can't really know exactly what they meant. Yeah, that's fine. You're right. We might not know exactly, but we probably have a pretty good idea. Most legislation has lots of debate notes and all sorts of articles and writings about it from the proponents of the law. And so you can get a pretty good idea, and then what you do is you're not evaluating. We don't have to figure out exactly what they meant, like every little detail, but you have two sides being presented to you in a case. That's what a judge has. He has a plaintiff and a defendant. And what he does is he looks at which of those two sides is better presenting what the law actually means. He understands what the law means, and then he sees these two cases. One says that they violated the law, the other side says that they didn't, and then the judge just has to judge between the two. So they don't need to know exactly what it means. It simply means that they need to say which of the two sides is more consistent with what the law is trying to convey. Now, another thing that people will say is that, well, times change. Okay, we have to have these judges because, like the Second Amendment, for instance, they couldn't imagine, bazookas and machine guns and all of these things at the time of the American Revolution when it was written. So we need judges to basically kind of reinterpret it based on the changing times. And that actually is not what the founders intended. There are some areas that may be a little bit vague or difficult to understand, but if that doesn't mean that we can jump away from the original intention of the law. For instance, let's use the Second Amendment. The original intention of the Second Amendment was to give the people power basically by arming them from abuses, not just from their primarily against abuses from government. Because if you study history and know anything about English history, you'll know that the English monarchy at different times would, or just the power structures in general in Europe and especially in England, would disarm different groups. And that led to those people being persecuted because they had no way to rise up in a violent revolution if the need arose. And so the founders wanted to ensure that the people had the means by which they could stand up to government power or to social unrest or anything else. Basically, it was the right to self-preservation. And this stuff, you don't have to guess it. You can go back and read what they said. Like, these people actually wrote this stuff down. Go read the notes. Go study the philosophers that they were studying. And you'll see it becomes very clear what they were trying to convey. And so in that same spirit, yeah, there still are some vague issues that we have to work out, but it all should be done with the backdrop of what it is that we're trying to figure out is what was the original intent, and is this thing that we are proposing consistent with that original intent. Now, times do change, and that's why we have an amendment process, okay? But a lot of people say, oh, well, but that amendment process, that's really hard. You have to get 2/3 of the legislatures, or maybe it's 3/4, I can't remember off the top of my head, but you have to get all the legislatures involved, and it's really hard to get new amendments. And the answer is, yeah, exactly. And that's by design. The Constitution is meant to restrict federal authority and restrict changes in federal government so that they happen very slowly, gradually, and don't happen easily. And what that does is that if you actually read the Constitution, the 10th Amendment says basically anything not given to the federal government through the Constitution should be left to the states. So what it was meant to do was make it very difficult for the federal government to make any big changes, but to allow individual states to make those adjustments as they saw fit. So that was kind of the whole reason for it. And I want to read real quickly a quote from George Washington on this. He understood this. George Washington was on my side in this issue, okay? The founders already knew about this stuff. And he said that the basis of our political systems is the right of the people to make and alter their constitutions of government, okay? He understood that things needed to change. But then he goes on, but the Constitution which at any times exist till changed by an explicit an authentic act of the whole people is sacredly obligatory upon all. If the opinion of the people, if in the opinion of the people, the distribution or modification of the constitutional powers be in any particular wrong, let it be corrected by an amendment in which way the Constitution designates. He then warns, though, against judicial activism, really, when he says, but let there be no change or usurpation, I'm not sure if I'm pronouncing that correctly. For this, though in one instance may be the instrument of good, it is the customary weapon by which free governments are destroyed. In other words, the power that you're using today by having a judge stretch the meaning of a law beyond what the intention of the law was in order to get what you want, well, guess what? Today it may be used to help you. But what happens later when the other party gets in power and get their judges in place and they decide to stretch the meaning of the law? See, that's the danger of political power, is that if you get power and you use that power, times change. Power shifts. And then suddenly the power that you used can be used against you. The founders were keenly aware of this. And that's why they intended to make the original intention of the law the basis of a judicial interpretation. And we can look at a judge and say, hey, you are totally off base, dude. Like, people are all upset about Trump saying a so-called judge. Well, what Trump is upset about is totally justified. He should look at the judge's behavior, and if the judge is not acting within the bounds of the Constitution, and if he's just making up law kind of off the top of his head and is not interpreting original law, but just is kind of saying, well, I think it's better for society that we, let these people into our country, and so that's why I'm ruling this way. That's not justified. He has to show why in the law, in the original intention of the law, something was wrong. So, again, the founders were on the same page here. Okay? I mean, the guy who wrote the Constitution James Madison, he said, "Can it be of any less consequence that the meaning of a constitution should be fixed and known than the meaning of any law should be so?" In other words, what he's saying is that there's a fixed meaning to these things. That's why we write it down. In English history, the English had an unwritten and still have an unwritten constitution, which allows for a lot of interpretation to get really crazy and out of control. James Madison wanted to avoid that. That's why we went with a written constitution. James Wilson said, "The first and governing maxim in the interpretation of a statute is to discover the meaning of those who made it." Thomas Jefferson agreed as well. He said, "On every question of the Constitution, carry ourselves back to the time when the Constitution was adopted. Recollect the spirit manifested in the debates, and instead of trying what meaning may be squeezed out of the text or invented against it, conform to the probable one in which it was passed." Okay? So they understood that if you give the judges that kind of power to just make the law whatever they feel like it is, you have completely destroyed the power of representative government, because the people who make the law are the lawmakers. I mean, imagine you're a lawmaker. Imagine you get elected by the people. You're going to represent them. You go and you create a law, and it's a law to, I don't know, stop smoking, let's say. And the judge, you make this law, everyone's behind you. It's very, very clear what the law is meant to do. And then you have a lawmaker who says, "Well, I interpret this law to mean that it only means that you can't smoke if you're under the age of 3 years old." And you're like, "No, that's bullcrap. That isn't what I meant. I said that it's for people over, that are over 21 or whatever." Well, I interpret it to mean something different. Okay, now obviously by writing the law more specifically, you can get that kind of stuff. But it's very clear, regardless of what your intentions are, what the judge is supposed to follow. The judge is basically working for you to ensure that the law that you created gets applied as per your intentions. If not, then what are you doing? Why are you even a lawmaker? You just make a law and then a judge gets to just go and twist that law however they feel is best for society? That isn't the way our system was designed to work. A judge's job is not to be partial to any political ideology or movement, but simply faithful to the lawmaker's intentions, the people who wrote the law, why they wrote the law, and to carry out their wishes. That is the job of a judge. And anyone who tells you otherwise is trying to utilize the law, the justice system, to get the law to do what they want it to do. In other words, they're activists, they're not judges. These people want to push a particular agenda. In the case of Donald Trump with his travel ban, it's very simple what's going on, okay? People want to oppose the president, they're very upset about it, and so these lawmakers are, or they just disagree with the travel ban, and they're basically just saying that, yeah, well, we feel that there's a good enough case to say that we don't really interpret it that way. And we think that even though there are laws on the books that basically give you this express meaning, we don't think that's a good thing, and we're just making a judgment call that we don't think you should do that. That's a total violation of what their role is. So in the end, remember, you have every right to criticize what a judge does. Just because a judge rules and says that this is the meaning of the law does not mean that is the actual meaning of the law. The meaning of the law came about when the people created it. They were the ones authorized to create that law, and every judge should be evaluated based on if they are representing the intention of the original lawmaker. If not, then they're not a judge. They're basically legislating from the bench. And we're no longer ruled by a society of representative officials, of our elected legislatures who are supposed to create the laws. Instead, we're being ruled by the arbitrary whims of unelected judges. And that's a very dangerous path to go down. So something to think about, and I hope y'all will listen in the next time I make one of these videos.